Hello everyone, welcome to all on Niyati IS YouTube channel. Today I'm going to cover a topic of a current affairs of polity and governance, that is Assent to State Bill. इस टॉपिक को मैंने स्लाइड वाइज सेग्रीगेट किया हुआ है। सबसे पहले देखेंगे वाई इन द न्यूज़, सबसे पहले देखेंगे वाई इन द न्यूज़ एंड बैकग्राउंड ऑफ द टॉपिक। सेकंड, कोर्ट इंटरवेंशन को देखेंगे एंड कोर्ट यूज्ड पावर को देखेंगे। थर्ड, की हाईलाइट ऑफ द जजमेंट ऑफ द मंथ अप्रैल 2025 के वर्डिक्ट को देखेंगे। दैट इज अ वेरी इंपॉर्टेंट स्लाइड ऑफ दिस टॉपिक। एंड लास्ट, नवंबर 2025 के वर्डिक्ट को देखेंगे। Moving ahead, look at the background of the topic. Why in the news? Recently, Supreme Court in the state of Tamil Nadu versus the governor of the Tamil Nadu issued direction to ensure the timely approval of bill passed by the state legislature. Back in the 2020, November 2020 and April 2023, the state legislature has passed 13 bill. Out of 13 bill, 10 bill were whether withheld or sent back to the assembly without any communication. After that, repassing of a state assembly, the governor reserved it for the president instead of giving assent. In response, Tamil Nadu government filed a writ petition challenging governor prolonged inaction on important bill. Now look at what was the court intervention and court used power. Court held that governor inaction reserving the bail after repasses was legally invalid. So, precedent action on those bail were also declared null and void. Here, court used power under Article 142 of the Constitution, which empowers Supreme Court to pass a decree order necessary for doing complete justice under Article 142 of the Constitution. Before moving ahead on the key highlight of the judgment of the April month, first look at what are the constitutional provision regarding assent to the state bill of governor responsibility for a state bill, and what is the president responsibility for bill reserved by the governor. Now look at the first, governor responsibility for a state bill. Under Article 200 of Constitution of India, when state legislature pass a bill, it goes to the governor. Governor has a 4 option. First one, grant assent, then bill become laws. Second, withhold assent, then bill is rejected. Third, return for reconsideration with suggestion for amendment. But when same bill legislature pass with or without changes, then governor must obligated to give assent. And fourth one, reserve for president consideration. Here, governor may do this as soon as possible. Now look at the president responsibility. When governor reserve a bill for the president has a 3 option. First, grant assent, then bill become laws. Second, withhold assent, then bill is rejected. Third one, return for reconsideration with suggestion for amendment. Then legislature must reconsider and pass within 6 months. Look at here very carefully. The timeline 6 months is given in April month, There is no mention in the constitution that legislature must reconsider within 6 months. Okay. Now the presidents make a final decision to give assent to reconsider bill, whether it is a grant assent or withhold assent. Now look at a very important point, key difference. Unlike governor, president is not obligated to give assent to reconsider bill. Might be you get a question in your paper in multiple choice whether governor is obligated to give assent to the president or not, give assent to reconsider bill or not, or president is obligated or not. Now look at the key highlight of the judgment of April 2024. I have categorized the judgment in a point wise. First, court held that inaction is unconstitutional, despite being no prescribed time limit, no pocket or absolute veto available to the governor or president. In case governor president exhibit inaction, a state government seek a writ of mandamus from a competent authority. Here, look at mandamus. It is a writ under Article 32, that is a come under the fundamental rights. इसी चैनल पर प्लेलिस्ट में जाके अगर आप देखोगे तो रीड से रिलेटेड एक वीडियो पड़े हुए हैं, आप जाके देख सकते हैं. नाउ मूविंग अहेड, लुक एट द सेकंड पॉइंट ऑफ द जजमेंट. गवर्नर कांट रिजर्व a reenacted bill for president assent. Bail reserved for president assent in the first instance only, not reenacted bill. The governor can't reserve a reenacted bill for president assent. The bill reserved for president assent in the first instance only, not reenacted bill. But when governor decide to withhold assent for the bill, then mandatorily send it back to the state assembly. Important point, after reenactment of the bill, governor can't reserve it for the president. Only exception, bill presented in the second round is materially different from first instance. Basically, the point is governor can't reserve a reenacted bill for the president assent. The bill can be reserved for president assent in the first instance only. If the governor decides to withhold assent for the bill, then he must mandatorily send it back to the state assembly. And when the assembly reenact the same bill, the governor cannot reserve it for the president. That was the concept, that was the point in our constitution. But there is an exception is also there. Bill presented in the second round materially different from the first instance. Now look at the third point. Prescribed timeline for the assent of the bill. This time limit are mandatory. This time limit are important. This time limit are not amendment to the constitution. That is a very, very important point of this slide. Remember that there is a no where mentioned in our Indian constitution that about the time limit for the assent of the bill. It is a verdict of April month, but a judicial standard to ensure timely action and avoid arbitrariness. Now look at the timeline set by the Supreme Court for a state's bill in the month of April. If a bill passed with the Council of Minister advice, it has a time for 1 month, and if the bill passed with against the Council of Minister advice, then President must decide on a bill reserved by Governor within 3 months. Here, when the bill passed by the first Council of Minister, then assent to the bill reconsidered by state legislature within 1 month. That is the timeline set by Supreme Court in the April month. Now, look at the fourth point of the judgment. Governor lacks absolute discretion under Article 200. Under Article 163, there is a Council of Ministers to aid and advise the governor, except in the situation where governor is constitutionally required to act on his her discretion. The point is, according to Indian Constitution under Article 163, there is a Council of Ministers to aid and advise the governor in the same manner as there is a Council of Ministers for the aid and advice for the president. But there is an exception in situation where governor have to act according to his her own discretion. Now look at the exception scenario. Under Article 20, governor does not possess any discretion in exercise for his function and has to mandatorily abide by the advice tendered by the Council of Ministers. Okay, as we have seen that under Article 200, there is a Council of Ministers for the aid and advice for the to the governor. Now there is a certain exception cases also there where governor have to take decision on according to his her own discretion. Now, when a state bill derogate the power of a high court, then that bill must be reserved for president. That is the point number one. Second, a state bill which will become effective without a state bill which will not become effective without assent of president. There is a certain bill which is originate in a state legislature must be take assent of the president. That is bill imposing taxes on water and electricity, water or electricity under Article 288. Then it become effective after the assent of president. Okay, money bill and financial bill passed by the state legislature too, which is special provision of Article 207 apply during financial emergency under Article 360 is also become effective with assent of president. Now third one, bill relating to the subject enumerated in concrete list also become effective with assent of president. If the bill inconsistent with the union law or exiting law with respect to that matter. Now, bill relating to the restriction or interstate trade, commerce, intercourse, legislation imposing restriction on trade and commerce requiring presidential sanction. The point is, bill relating to restriction on interstate trade and commerce and intercourse, then that bill required assent of president. That is the all 5.5 type of bill, a state bill, become effective after the getting assent of the president. Now, 6.1. A state bill which require assent of the president to secure immunity under Article 1419. There are certain there are there is a certain states bill which originate in a state also require president assent to secure immunity from under Article 1419. That is Article 31A providing acquisition for the states and 31C giving effect to the certain directive principle. This also become effective after the assent of president. Now, where the bill is a nature that if allowed to take effective, then it would undermine the constitution. Now look at the discretionary power under the Article 200 is subject to judicial review. Now, on previous slide, we have seen that there is a certain discretionary power with exception for the governor. Now look at whatever the discretionary power taken by the governor is also subject to judicial review. That is here. Grant of assent by governor or president on advice of council of minister may not be justiciable. Whatever the grant of assent given by governor in the state and president in the central government or council of minister in the Lok Sabha may not be justiciable. Withholding assent for the reserving bill using the governor discretion can be challenged in court. If the governor acts against the advice of state, now very important point is here. If the governor acts against the advice of council of state council and reserve bill for president, the state government can challenge it in the High Court or Supreme Court. The point is, whenever governor act against the advice of state council and reserve bill for president, that case the state government can challenge it in the High Court or Supreme Court. That is the case between Tamil Nadu state government and Tamil Nadu governor. Now look at here. If the president withhold assent, then action can also be challenged in the Supreme Court. In the same way, if the president withhold assent, then that action also can be challenged in the Supreme Court. Now, look at the 6th point of the judgment. President should consult Supreme Court on bail reserved for unconstitutionality. Whatever, let's suppose there is a bill which originates in any state legislature, and that bill is something like unconstitutional provision. In that case, president should consult the Supreme Court. Now look at here. If a governor reserve a bail for president assent due to the concern for unconstitutionality, then what are the options available to president? President should seek Supreme Court opinion under Article 143. Under Article 143, President's power to seek advisory opinion for Supreme Court on question of law or fact. The important point is, President may disagree with the court opinion only for valid reason and must provide clear justification for doing so. Whatever President do, have to provide clear justification for that under Article 143 of the Constitution. That type of consultation include governor cannot refer such matter to court. गवर्नर ऐसे मैटर को कोर्ट में रेफर नहीं कर सकता है. सुप्रीम कोर्ट इज द फाइनल अथॉरिटी ऑन इंटरप्रिटेटिंग द कॉन्स्टिट्यूशन एंड लॉ. And third one, the court's opinion under Article 143 hold a strong persuasive value and should generally be followed by both Parliament and President. Whatever the opinion held under the Article 143 of the Constitution is a very persuasive value and followed by the both Parliament and President. Now look at the last slide of this content, that is Supreme Court on assent on bail. That is the case of November 2025 when our President Draupadi Murmu counter a number of questions or ask a number of questions to Honorable Supreme Court regarding the time limit set by Supreme Court to act on state's bill by governor or president. Here, a 5-judge bench of Supreme Court in the 16 presidential reference under Article 143 held that court cannot be imposed any timeline for decision of presidents and governor on granting assent to the bill under Article 200 and 201 of the Constitution. That is a very, very important verdict of the November month. Look at here. Earlier in April, the Supreme Court set a time limit to act within 1 month and 3 months. If you remember, I have discussed here the timeline set by Supreme Court for the state bill. That is the case. It is the verdict of April month now. Now look at in the November. Supreme Court, 5-judge bench of Supreme Court said that court cannot be impose any timeline for decision of the president and governor on granting assent to the bill under Article 200 and 201 of the Constitution. But as I mentioned previously, in April 2025, Supreme Court prescribed a specific time limit for the governor and president to act on bill under Article 200 and 201, as I shown you in the last slides. Under Article 143, allow the President to seek opinion of the Supreme Court on significant legal or factual question. Recall all previous mentioned article like 200, 200, 201, 163, 142, 143. That is a very dynamic nature of this topic. I think this is the only topic which counter almost around 10 article of the Indian Constitution. That's why it become a very important topic for UPSC CSE PT as well as mains and even state PCS as well. Now look at the other key highlight of the judgment. That is the month of November. Deem assent is court held that deem assent is alien to the Constitution. जैसे लास्ट स्लाइड अप्रैल में सुप्रीम कोर्ट टाइमलाइन सेट किया हुआ था कि विद इन दैट टाइमलाइन if the governor is unable to give assent to the bill that there is a deemed assent, तो वो माना जाएगा कि उस बिल पे गवर्नर ने assent दे दिया हुआ. That is the word deemed assent. Court cannot assume that bill is approved merely because the court order time has lapsed. Listen, in April month, as Supreme Court fixed a timeline to act within the timeline by governor and president, but here court said that the bill is merely not approved because the court order time has passed. It would amount to judicial usurpation of the constitutional power of the president and governor, violate separation of power and constitutional scheme of the federal scheme. That is a very, very important point for mains as well. Here, separation of power and the constitutional scheme of the federal governance is also come under the line. Governor president cannot sit on the bill indefinitely, as it violates federalism, legislature will and unconstitutional morality. Third point is limited judicial review. Court can intervene if the governor president acts with malified intent. Review limited to process, not merit of assent. Fourth one, president is not required to seek advice of Supreme Court whenever governor reserve a bill for assent, as a subjective satisfaction of the president is sufficient. Basically, the point is the key highlight of the judgment in the November from the April is that as Supreme Court in the April month said deemed assent, but here November the Supreme Court said that deemed assent is alien to Constitution. Means if the governor unable to give assent to that bill, to a particular bill in a given time frame, that is the time limit set by the Supreme Court in the April month, is alien to Constitution. बेसिकली नवंबर वर्डिक्ट में दिसंबर के जो टाइम लिमिट सुप्रीम कोर्ट ने सेट किया हुआ था उसको हटा दिया है और बोला है कि दैट इज डीम्ड एसेंट इज एलियन टू द कॉन्स्टिट्यूशन. ये कॉन्स्टिट्यूशन में मेंशन नहीं है. अपार्ट फ्रॉम दैट सुप्रीम कोर्ट सेड दैट गवर्नर प्रेसिडेंट कैनॉट सीट ऑन बिल indefinitely as it violate federalism, legislature will and constitutional morality. And third point is said that whatever governor and president do with respect to the state legislature bill has a limited judicial review. Court can intervene if the governor and president act with the malified intent. And third one is the president is required to seek advice of the Supreme Court whenever a governor reserve bill for assent as the subjective satisfaction of the president is sufficient. President is not required to seek advice of Supreme Court whenever governor reserve the bill. गवर्नर जब कभी भी बिल रिजर्व करे तो ये प्रेसिडेंट को रिक्वायर्ड नहीं है कि वह प्रत्येक टाइम सुप्रीम कोर्ट से एडवाइस ले. दैट इज द पॉइंट. नाउ दैट्स द होल न्यूज एंड कवरेज ऑफ दिस टॉपिक फ्रॉम my April 2020 to 2025. Generally, this topic is evolved from the April 2025 then to November 2025. Okay, that's all about this topic. Apart from that, if you still have anything, then let me know in the comment section. Thank you for watching this video. If you still have something, then let me know. In the comment section. And make sure to join Telegram channel to get PPT of this class. Thank you for watching.